I think the Republicans are back, ready to start if our colleagues are ready.
I will text Representative Sylvester.
I think we're all alone.
And just so you guys are aware, I did start the live stream after I sent you guys to caucus. So just letting you know.
What did you do?
I started the live stream to YouTube. That way, when you guys came back, we could get going.
Excellent. Thank you for your help.
Not a problem. Senator Rafferty, I just wanted to let you know that I did start the live stream, so you guys can begin whenever you're ready.
Thank you very much, Alyssa. I appreciate that. Good afternoon, folks, and thank you for joining us here today, again, on our YouTube channel. We are actually in a work session relative to two bills that we'll be discussing today. And those bills are LD 61 and LD 111. I'll review those momentarily, but please keep in mind that during the work session, this is still, again, all new to us. We're going to have some issues potentially, but we ask that you be patient and we'll work through it together. The purpose of the meeting really is for the committee to receive information from staff and others in order for the members to consider the legislative proposals before them and make recommendations or reports to the legislature. Only committee members, the committee analysts, and those specifically invited to attend will be participating in the work session using Zoom. For members of the public wishing to observe this meeting, it's being live streamed on the committee's YouTube channel and will be recorded for reviewing after this meeting is concluded. We're also broadcasting the audio of the meeting on the legislative website, www.legislature.maine.gov. In any case, so you'll be observing and listening to the discussion among the committee itself. We'll ask one another questions, perhaps just trying to think through the bill and its implications. And we may ask for some clarifications from sources that are with us. And first up, the bill we're going to take a look at is an LD 61. And this is an act to include grandparents under Maine's family medical leave laws. And what I'm going to do is call upon our analyst, Steve Langland, to give us some information that he's provided. Steve, good afternoon, and thank you for helping us out today.
Sure. So I'm going to share my screen. I did send my bill analysis to you in advance of the meeting. I don't know if you had a chance to look at it, but so LD 61 is an act to include grandparents under Maine's family medical leave laws by Representative Stearns. So the bill allows a grandparent to request employee family medical leave in order to care for a grandchild who has a serious health condition. The committee received testimony from the sponsor as well as written testimony, and it's hyperlinked here. So if you have it up on your computer, you'll be able to click on this and it will take you right to the testimony. Representative Stearns said that caring for a grandparent in the absence of a parent is a natural occurrence. He indicated that his intent with the bill is to let grandparents take leave to care for grandchildren with serious health conditions and not caregiving. He did offer an amendment, which I also sent to you, and it's attached to the bill analysis, but I sent it prior to the work session for your review. So the amendment, which I'll go over again, defines grandchild to mean living with the employee or the employee's domestic partner. We also received testimony from Isaac Gingras in the Maine Department of Labor, and I also attached his testimony. So in his testimony, he said that the definition of child is uncertain and could be clarified, and that it would be helpful if the committee provided further definition of a grandchild, such as biological, if the committee is thinking along those lines. And with Representative Stearns' permission, I did share the amendment that I drafted, and the department indicated that Representative Stearns' amendment does clarify their concerns around the language. The committee also received testimony from Jeff Young from the Maine Employment Lawyers Association. His testimony, he said that states including California, Washington, New Jersey, and the District of Columbia include grandparents in their definitions. And he said that he believes the bill should expand coverage to include parental and grandparent leave to care for children and grandchildren unable to attend school because of COVID-19. The only opponent of the bill was Stephen Bailey of the Maine School Management Association, and he was concerned that the bill as written would allow teachers who are grandparents to take time off from teaching to care for their grandchildren while the grandchildren's parents go to work themselves. Testifying neither for nor against were Kate Dufour of the Maine Municipal Association, and she also shared concerns with others about the definition of grandchild and grandparent and that it should be strengthened. Peter Gore of the Maine State Chamber of Commerce also testified neither for nor against. In his testimony, he said that it can become a slippery slope when you add new categories to accepted leave. So where does it stop? He said that compliance is difficult for small businesses because leave is allowed in increments, and that the intent of this statute is only designed to be used for a serious health condition, which I have included on the next page for your view. So the only thing that I wanted to point out is that there was a lot of discussion in the public hearing on whether the bill's intent is to allow caregiving or whether it's for medical leave. So the sponsor indicated to me that his intent is medical leave. And in reading the statute, it's clear that the intent of the statute is to allow medical leave. So requests for information from some of committee members. So Senator Guerin wanted to know if both a parent and a grandparent could take FMLA for the same child, which she referred to as double dipping. So I'm unaware of any provision that forbids this, but the FMLA does provide that spouses who work for the same employer are allowed only a combined amount of time under some circumstances, such as the birth of a child. And I have attached a federal Department of Labor bulletin that summarizes when this might be applicable. Representative Drinkwater wanted to know about part-time employees and if they can benefit. So the way the Maine law is written, it specifies any employee. It doesn't define employee to mean working a minimum number of hours. However, the employee can only take leave after working for the employer for 12 consecutive months. There was discussion about whether this leave policy is guided by Maine Department of Labor rules, and I'm unaware of any rulemaking in relation to this statute. There was discussion about whether a grandparent can take the place of a parent and use FMLA. So yes, there is, if a grandparent is acting in loco parentis, FMLA can be used, and I'll go over this again on my attachment. So what I did want to point out is that family medical leave and the way that this bill is written, it seeks to allow leave for a grandchild with a serious health condition. And serious health condition is further defined in this bill to mean an illness, injury, impairment, or physical or mental condition that involves inpatient care in a hospital, hospice, or residential medical facility, or continuing treatment by a healthcare provider. The committee has not yet received a preliminary fiscal impact statement. So this is a chart that I put together that sort of summarizes FMLA versus the Maine family medical leave requirements. So the biggest difference is in who it covers and how much. So FMLA federal is 12 work weeks of leave in a 12-month period after working for employer for 12 months. But federally, the 12 months of work does not need to be consecutive. So it could be seasonal, for example. But in the Maine family medical leave requirements, which this bill would amend, the employee is allowed up to 10 work weeks in any 2-year period after being employed by the employee for 12 consecutive months. So federally, to get FMLA, the employee has to have worked 1,250 hours during the 12 months prior to the start of leave. But under the Maine family medical leave requirements, any employee, regardless of full-time or part-time status, can receive it. There are no hours worked requirements, such as under FMLA. So both federally and state can be unpaid. And federally, 50 or more employees is what constitutes a covered employer. And 15 or more employees at one location in Maine is what a covered employer is under the Maine family medical leave requirements. So here is the testimony from the Department of Labor. And this is Representative Stern's amendment. So what it does, so the original bill just inserts the word grandchild and domestic partner's grandchild. But this adds a definition for grandchild. So it would mean that grandchild is a child of the employee's child or a child of the domestic partner's child that resides with the employee or domestic partner. So it means that an employee can take leave to care for a grandchild, but only if the grandchild resides with the employee or the employee's domestic partner. So backing up a little bit to what I referenced above in my attachments. So there, like I said, there are some provisions where FMLA is limited if two employees work for the same employer, spouses. So when spouses work for the same employer and each spouse is eligible to take FMLA leave, the FMLA limits the combined amount of leave they may take for some, but not all qualifying leave reasons. So eligible spouses who work for the same employer are limited to a combined total of 12 work weeks of leave in a 12-month period for the following reasons. So like the birth of a son or daughter and bonding with the newborn child, the placement of a son or daughter with the employee for adoption or foster care and bonding with the newly placed child, and the care of a parent with a serious health condition. And it kind of goes on. And this is kind of a handy little chart that kind of shows the overlap. So everything in here is a combined limitation on what can be used for federal FMLA. And then it has a couple of examples that I'm not going to go into, but it's there if you want to peruse it. So my second attachment here is about when somebody acts in loco parentis. So the Family Medical Leave Act federally defines a son or daughter as biological, adopted, or foster child, a stepchild, a legal ward, or a child of a person standing in loco parentis. So it's not entirely clear in every circumstance what constitutes standing in loco parentis, but the courts and others have determined that there are some factors which can be considered if somebody's standing in loco parentis. So courts have indicated some factors include the age of the child, the degree to which the child is dependent on the person, the amount of financial support, if any, provided, and the extent to which duties commonly associated with parenthood are exercised. So they also, so I should say the specific facts of each situation will determine whether an employee stands in loco parentis of the child. So here are some examples in which that may qualify. So a grandfather may take leave to care for a grandchild whom he has assumed ongoing responsibility for raising if the child has a serious health condition, or an aunt who assumes responsibility for caring for a child after the death of the child's parents may take leave to care for the child if the child has a serious health condition. And it goes on further to discuss, what sort of documentation might be required. Basically, the documentation can take the form of a simple statement asserting the relationship. But I know the committee hadn't exactly asked for that, so I don't want to overstep and further potentially confuse. So that is all that I have on LD 61. I'm happy to try and answer any questions, and I will point out that there are members from the Department of Labor here as well, and they should be able to answer some questions too.
Thanks very much, Steve. I see a hand up for Senator Guerin, please.
I wanted to ask Steve, when he was speaking about the federal program, if there's any provision for grandparents in federal legislation.
So are you talking about legislation that's pending, like sort of mirroring what is before the committee now, or?
Any laws in place that are allowing grandparent paid family medical leave at the federal level?
Yeah, so I'm not aware of any proposed laws by any federal legislator. But as I said, there are provisions in the FMLA that let a grandparent potentially take leave to care for somebody with a serious illness if they're standing in loco parentis. So to my knowledge, there hasn't been any further amendments or other things proposed that would sort of extend that federally.
Thank you. Representative Bradstreet, followed by Representative Pebworth, please.
Thank you, Mr. Chair. Thank you, Steve, for this. In loco parentis, is that something that is a legal declaration, or is it, beforehand, somebody's designated as a parent in loco parentis, or is that something that evolves during the process? I think you just said, I think I read somewhere here too, that a person can just sign a note saying I'm in effect the parent. So there's really no tight definition of that.
No, my understanding is that it's sort of situational. So, for example, if a child's parent dies and unexpectedly, then the grandparent kind of assumes those responsibilities. So they might be taking care of them, providing financial support, etc. So they're kind of standing in loco parentis. I don't think that there is, one specific definition necessarily. But as I pointed out in the US DOL bulletin points out, there are certain circumstances which the courts have found that constitute what exactly it means to be standing in loco parentis.
Thank you, Steve. Representative Pebworth, followed by Representative Cuddy, please.
Thank you, Mr. Chair. Thank you, Steve. My question is about the proposed amendment. And if I am understanding it correctly, if I am a grandmother and I have custody of grandchildren and they live with me, we are outside of this definition?
I'd have to take a look at that. So I know the sponsor's intent was to have the grandchild be living with the person who was going to be assuming the responsibilities and who would be requesting the leave from the employer. I don't know. It's possible that also my language needs to be tightened up and reviewed as well, but I'm happy also to defer to the sponsor if he has any further explanation on what his intent was as well.
Is that my
Thank
cue to
you.
unmute? The amendment covers living with the grandparent or residing with the grandparent. Another way to put it would be in loco parenti. And obviously, if the person has custody, they would already, in my opinion, already be covered by state FMLA. If they have custody, they are in essence the parent of the grandchild.
Thank you. Representative Cuddy.
Thank you very much, Senator. Yeah, Steve, I was looking at, I scrolled, that's my own fault. The testimony from Isaac Gingras from Maine DOL. MDOL sort of saw the addition of the definition as just a general plus. I think they wanted to tighten up the definition of child, tighten up the definition of grandchild. And this works on the definition of grandchild, just in terms of that, fairly clear statement of means a child of the employee's child or a child of the domestic partner's child. So it seems like that is in there to address that direct concern. There is no mention of the definition of child, and I don't know what the definition of child currently is in law. Is that referenced anywhere?
So you're right in pointing out the DOL thought the definition of child could be strengthened as well by adding, I believe, the word "the," because the way the statute is written, it says leave will be granted to an employee. So by adding "the," you would say like the employee's child was the idea behind the Department of Labor's testimony, is what I'm understanding. So it wasn't clear to me that the sponsor felt the same way, so I didn't add on that language, but I don't think that the department would find that problematic, given that it was one of their suggestions. But yeah, I think that there might be, and I don't know off the top of my head, there could be a definition of child maybe in Title I that speaks generally about statutes, but I'd have to take a second look at that.
Okay, so it sounds like regarding the definition of child, the addition of the word "the" would specify that it was not a child, but it was actually the child of the employee specifically that we're talking about.
Yeah, that's my understanding. Yeah.
Okay, that seems quite reasonable. Okay, thank you.
Thank you. Representative Sylvester, and then I'm not sure, Representative Bradstreet, do you have your hand up again, or? Okay, and Senator Garin?
Thank you, Mr.
We'll
Chair.
go,
Oh, sorry.
yes.
Go ahead.
That's all right. Go ahead, Representative Sylvester.
So just to piggyback on Representative Cuddy, I think the first part of that definition is doing a lot of work in terms of defining who the grandchild is vis-a-vis the grandparent, and who the grandparent is vis-a-vis the grandchild. I don't see the need for the residential piece per se, because the employer has the right to deny the leave if they feel that it's some kind of crazy situation that, you know, where people are trying to abuse the system. And so I was wondering if I see Mr. Rowland, I'm wondering if he could come up and speak about what part of that the department was trying to define. If that, with your leave, Mr. Chair.
Yeah. Oh, okay. Sorry.
Yes. Please.
Let me know if you want me to.
You're good, Mike.
Okay. Yeah. Well, and I'm going to ask Scott Cotnor, who is our wage and hour director, to join us as well. But I would start out by saying we're sort of indifferent whether it's residing with the parent or the grandparent or not. That's up to the committee and the legislature. We just want clear language on what the intent is of the legislature. So Scott, are you here?
Yes, I am.
Yeah. Do you have anything to add to that?
Right. Whether putting a definition of grandchild in there definitely clarifies the law. Whether or not that grandchild resides with the employee or domestic partner is irrelevant from wage and Department of Labor standpoint. I think that's in there because that's what the sponsor wanted to address or specify.
Mm-hmm. We just needed to clarify for reasons of interpretation. I think I would back up, if you'll let me, to the last discussion of what language to insert to clarify the child, not the grandchild, but the child. It's not just the word "the," but the words "the employee's child," I think, is what we would prefer to see for reasons of clarification.
Thank you.
Yep. Okay.
Representative Bradstreet and Representative Rader, please.
Yes, thank you again. I'm back to in loco parentis. Couple of questions. When that is designated, that is one person, right? And also, while that designation, a person holds that designation, does the biological parent still have parental rights and responsibilities, assuming that he or she is still alive?
I don't know the answer to that off the top of my head. I'd have to do a little more research on, how that affects the parent is still living. But I know that generally, like I said, it's kind of a situational thing where somebody kind of stands in place of a parent. So it's not clear to me that that means the parent has to be necessarily deceased. But it's somebody who's sort of taken on that role. And that can be demonstrated, financially and caretaking and living with them, etc. So I don't know that answer off the top of my head.
Representative Rader, followed by Representative Gear, and Senator Guerin, I had asked, I'm not sure if your hand's up a second time or is it just still up?
It's up a second time.
I'm sorry. Thank you. Representative Rader, please.
Thank you, Mr. Chair. That FMLA at the federal level talks about in loco parentis being a situation in which someone is caring for a child without a formal guardianship or custody situation. So in my way of thinking, and this is something I'd love a little bit of clarification on, the parent doesn't have to have relinquished custody. The parent might still be alive. And there's another definition here I wanted to share. In loco parentis refers to a relationship in which a person puts himself or herself in the situation of a parent by assuming and discharging the obligations of a parent to a child. The in loco parentis relationship exists when an individual intends to take on the role of a parent to a child who is under 18 or 18 years of age, of older and incapable of self-care because of a mental or physical disability. And in loco parentis, in terms of FMLA, is sort of on a case-by-case basis as well, it seems to be. It feels like a really good definition for a jumping off point for us, because then residency isn't necessary. We don't have to get into the weeds of custodial parents or guardians. Thank you.
Thank you. It's a great point. Representative Gear, followed by Senator Guerin.
Thank you, Mr. Chair. Yeah, I think Representative Rader's point was really along my lines of thinking, because the fundamental question I have is there a situation where a grandparent could be acting in loco parentis where the child would not reside with them, either wherever that is, together, because you need to care for a child, needs to be in a situation of caregiving and cannot be out there living on their own. So that's why if there's not a scenario that violates that principle, then it would seem that the residency amendment would be redundant with the in loco parentis language.
Thank you. Senator Guerin, please.
Thank you, Mr. Chair. I have several questions, really. A lot of it goes along with the resides. The definition of resides, how are we going to define that? And what does that even really mean? It means reside with them after school. They reside with them on weekends. If it's on a permanent basis, how is that provable if you haven't gone to court to get that? And who would that be left to investigate? An employer would need to investigate in some way to find out if the person actually does have the children living with them when it isn't a custody situation. It's just an informal arrangement. And it does sound to me like in this situation, maybe 3 people or possibly 4, if you count the partner or spouse of the grandparent, could get the leave. Each parent could get the leave from their job, and then each quote grandparent could get the leave. I just think there's a lot of ambiguity there. From serving 6 years on the Judiciary Committee, I know we looked hard and long trying to find ways to give grandparents more rights and help from the state, because we have so many grandparents who are stepping in and filling that void. Representative Prashadi brought really dozens of bills as a grandparent who was really stepping up, he and his wife, and they were part of a grandparents group. But we couldn't find anything that constitutionally protected the parents and at the same time helped the grandparents. I think we're getting into an area that is so weedy here that the definitions are unclear and the enforcement is left to businesses that really have no enforcement tools. You know, if it's in the hands of DHHS, then they have enforcement tools, but an employer have the right to go in and launch an investigation into your family life.
Well, thank you. Anything else? Anyone? I would go ahead, Representative Sylvester. You're muted, Mike.
I was just saying that if there wasn't any more questions about the analysis, then I was ready to take a motion, but I wanted to make sure that people didn't have further questions about the analysis before I did that.
I'd make a comment if I could. The term resides, I mean, when Representative Guerin was saying we're looking for ways to help grandparents, I think the removal of the word resides is more beneficial, more helpful to grandparents than to keep it in there. And I think a grandparent that perhaps might live next door was taking care of a sick grandchild would be, doing what this law is intended to do, or helping in a way this law is intended to allow, even though technically the child wasn't living in their house, but they were responsible for the care of that child while it was sick. Senator Mermont, followed by Senator Guerin.
Thank you, Mr. Chair. And I'm not quite clear from your last statement. I think that the bill is fine without the amendment, and that goes to what you were saying. And if so, I'll offer an ought to pass with no amendment, just as the bill is presented to us. That's my motion, unless I'm misunderstanding what you were saying, which would then require more discussion. But if I've got that right, that's a motion.
And I have now lowered my hand.
Thank you.
I will second Senator Merrimont's motion.
I apologize. My internet has been a bit spotty. I could not, I didn't get all of Senator Merrimont's motion.
I'll ask him to repeat it.
Yes, thank you. The motion is to pass the bill, ought to pass as presented, no amendments, period.
And it has been seconded. Further discussion? Representative Bradstreet.
Yes, thank you, Mr. Chair. I also served on the Judiciary Committee 1 year when we tried to tackle this definition of child and parent and grandparent thing. And it is a lot more complicated in its application. I think that we're seeing right here. My reservations with the bill is that it does open up a slippery slope as to what could happen down the road. I also know that there have been a number of efforts to expand Maine's Family Medical Leave Act. And if we do that, this will go along with it. So reluctantly, I'm going to have to vote against the motion. I wish it was something we could do. And I certainly appreciate the representative for bringing it forward, because I'm a grandparent too, and I could find myself in this situation. But the downside, I think, outweighs the upside. Thank you.
Thank you. Representative Cuddy, followed by Senator Mermont.
Thank you, Senator. I like the bill as it's brought forth. I actually brought a bill forth last session and was able to add great grandparents into a statute that covered grandparents when it dealt with the ability to see kids in places where there's a divorce and the grandparents' rights to see children. But Maine statute largely gives rights and protects the rights of the parents, and it doesn't protect the rights of grandparents and great grandparents, which is one of the things I really like about Representative Stearns's bill, is that it's not giving the grandparent a right to access the child. It's giving the grandparent the ability, if they're working, to take care of that child. And that's going to assume that the parents are on board with that. And they've probably even asked the grandparent to watch the child when the child is really sick. So I think Representative Stearns's bill fits into that very, very well. The one thing I would like to see us do, though, is include the part of the sponsor's amendment that defines child or defines grandchild. Striking, and I don't know my parliamentary well enough to know if I can move to amend an amendment. But assuming for a moment that I can, I would like to amend it so that we would include the sponsor's amendment, striking the phrase that resides with the employee or domestic partner. Because I think Senator Guerin is right that resides is going to, it's I think Senator Rafferty was right. It's going to limit things, and B, it's going to offer up some ambiguity that we don't need to put in. And in fact, a better bill without that. And I would further like to, and I'm going to look to Steve for a little bit of assistance to make sure I'm doing this in the right place. I'd further like to add in section 843(4), paragraph D, where it says a child, I'd like to add the employee's child. I believe that's where Mr. Rowland was suggesting that we could add some clarity. And assuming that is where he was suggesting it, that's where I'd like to put it. So if it's possible to amend an amendment, which I'm not sure I can do, that's what I'd like to do.
I'm going to go Representative Sylvester, and then Senator Guerin.
Just to, and Steve can tell me if I'm wrong here, but what you would have to do, Representative Cuddy, is to offer a friendly amendment to Senator Miramont's amendment, which he would then have to accept because there is already a motion on the floor and seconded. So we would either need to vote on this as is and have it defeated for you to offer another motion with that amendment. He would have to accept that, or there was a third option, which just flew out of my head. But basically, at this point in time, Senator Miramont would have to agree to your amendments.
Okay. I'm a very friendly person, so I'll offer it up as a friendly amendment. But if Senator Miramont doesn't want that, I perfectly understand.
There's two ways to find out. It's not just me, it's kind of the committee. So there's two ways to find out. Go ahead with the vote, and if I lose, I lose, or go to caucus and explain why you think that is stronger than what the original bill does with no amendments. I'm open to either. Sorry, Mr. Chair, you didn't call on me. Thank you, Mr. Chair.
Thank you, and thanks for the clarification. Senator Guerin.
Thank you, Mr. Chair. I was looking through Peter Gore's testimony that he gave at the public hearing, and he had some questions about removing the emergency preamble, and his ideas, I think, were pretty good. Because education is going to be a key point in this. If you do indeed pass it and it passes and is signed by the governor, there would need to be some time to educate Maine's businesses, especially Maine's small businesses that don't have HR departments. They're going to have to be educated on how to implement this, because it is quite a drastic change in policy, and one that require quite a bit of oversight from a business point of view. So I'd ask you to consider removing the emergency preamble.
Thank you. Representative Sylvester.
I got it. So Senator Guerin, again, I think that there's two different ways that could happen. One is a friendly amendment. One, if the motion passed as on the table, that could be a separate motion to remove the emergency preamble. If you think about it, sort of like when we get unfunded mandates and we add stuff on after when we get it late. So that's sort of a procedure because we have a motion on the floor that's been seconded. So you could offer it as a friendly amendment, or you could offer the emergency piece after we voted on the first part.
I guess I would be offering it as a friendly amendment, and if you are going to caucus, you could discuss it. Sorry for not asking permission to speak. Oh my gosh, trying to run this computer and keep all my rules in my mind is difficult.
It's okay. We are in a work session and we're trying to do our work, so don't worry about it. Representative Sylvester.
I guess I would just to finish, I was going to ask Representative Stearns if he had thoughts about well, I guess actually since there's a motion, I can't do that. Never mind.
Any further discussion? Representative Bradstreet.
Yes, thank you, Mr. Chair. Do you need a second on the friendly amendment? If you do, I will second that.
Thank you, sir. Why don't we take a 10-minute caucus and square away our thoughts, come back and go from there. Alyssa, can you give us that break rooms, please?
And Representative Bradstreet, I didn't see your text till later, so if you guys are ready to come right back in, feel free to let me know.
Okay.
Okay, I'm trying to send you guys to the breakout rooms. Are you all seeing the breakout rooms closing message?
I'm not seeing
No?
any message.
Okay. I think I have to give it a few seconds to close and then I can reopen them.
No problem. Thank you. Senator Guerin, I'm sorry if your hand's still up.
I'm sorry that I again forgot to put my hand down.
That's okay.
Okay. You all should be seeing the message now, I believe. Perfect. Okay, Brooke, I was going to add you to their caucus, but for some reason the breakout rooms are closing again.
Ah, okay. Thank
Yes,
you.
I did not mean for that to happen.
That's fine. And I joined a little late, so no problem.
Okay, I apologize. I'm not sure why it pulled you all back in, but they just closed and now they're open again. So one of the many mysteries of Zoom.
All right, everyone take 60 more seconds.
Yeah, we were in the middle of a conversation when we got
I apologize. I didn't click to call you guys back. They just closed when I went to add Rep
Oh,
Cuddy.
okay.
I feel like it's NASCAR.
Talk fast.
Are we all waiting for that message again?
Yes.
It shows that they're open on my end. Do you all have the little breakout rooms button at the bottom?
No.
No.
We do have it at the bottom, or we ought to.
It's like, because a couple of people have left, so I don't know.
Oh, I can go now. Yep.
You mean that leave button in the lower right-hand corner?
No, because you don't want to leave the meeting. On like the bottom bar, you should have like a bunch of options like reactions, share screen. One of them should say breakout rooms. It's like a little grid with 4 squares.
Oh, yes, right there.
Perfect. And I apologize because that was not supposed to happen.
I don't see my name up there yet.
Do you see the little bottom bar, Senator Rafferty?
I do, and the thing's up, but my name doesn't appear. What popped up was who's in it and an option to close all rooms, but my name is not on the
Okay.
list to go into it.
Don't close the rooms because then everybody will come back.
I won't do that. No, I don't want to touch anything. I just don't see my name.
I'm
I see
wondering if
everyone,
yeah,
everyone but
I think because you're a co-host, yours looks different than. Oh, I don't have the only. Okay. I'm going to try something.
okay.
So basically right now, my only option is to send you to the opposite caucus. And so I was hoping I could make a third room, but now it won't let me.
You won't want to do that. You're going to catch hell.
Do you see when you click on the breakout rooms, do you see the little blue button that says join?
I have no, the only thing I have is close all rooms, and then it shows me the breakout rooms, who's in each one, and who's not in a room.
Right. So where
my
it says D and then like the list of everybody that's in it, on the right side of that little panel should be a blue button that says join.
Okay. I'm just.
Okay. Perfect. It worked. And Brooke, you want to go to theirs, right?
Yes, the Democrat,
Okay.
please. Thank you. I'm seeing the button now. Thanks so much, Alyssa.
Not a problem.
I believe the Republicans have returned. Alyssa, are we all back, or what is the status at this point?
It looks like the other caucus just came back.
We are ready to roll anytime you are, Senator Rafferty.
Yeah, I'm just looking to see if I can get my gallery back. I'm kind of being blocked out here. Let's see if I can get my view gallery. Okay, we ready to move the motion? So Alyssa, we're going to take a roll call vote. And just to clarify, the motion on the floor is to, if you vote yes, you're voting yes as an ought to pass, a no vote would be not pass. And the motion currently is an act to include grandparents under Maine's family medical leave laws. The motion was to vote as it was written without any amendment.
Point of order, Mr. Chair. I'm just asking if there's an amendment on the floor. The amendment to remove the emergency preamble. I'm just asking that.
It was seconded without the amendment. That we did discuss the amendment, but I will. Is there anyone else under the assumption? Representative Sylvester.
So it was offered Representative Bradstreet as a friendly amendment, but that friendly amendment was not accepted. And so the motion as also was not the friendly amendment from Representative Cuddy. So at the present, it's a motion ought to pass as written by the sponsor.
Okay, thank you.
Alyssa, if you would, anyone need to review there quickly on the yay is approved as written, all right? Alyssa, if you would do please a roll call vote.
Certainly. Senator Rafferty.
Yes, ought to pass.
Rafferty, yes. Senator Guerin.
No.
Guerin, no. Senator Miramont.
Yes.
Miramont, yes. Representative Sylvester.
Yes.
Sylvester, yes. Representative Bradstreet.
No.
Bradstreet, no. Representative Cuddy.
Yes.
Cuddy, yes. Representative Drinkwater.
No.
Drinkwater, no. Representative Gear.
Yes.
Gear, yes. Representative Morris.
No.
Morris, no. Representative Pebworth.
Yes.
Pebworth, yes. Representative Prescott.
No.
Prescott, no. Representative Rader.
Yes.
Rader, yes. And Representative Warren.
Yes.
Warren, yes. So that is 8 yeses to 5 noes, with none absent.
Thank you. So the motion it carries. Thank you, Alyssa. We have before us, LD 111. Where am I? Yeah, here we go. An act to allow career educators to retire without penalty. And I will ask Steve, if you would, please give us a review of your, and I'm just going to run to my door and let my dog in. I'm listening.
Okay. So LD 111. So LD 111 is an act to allow career educators to retire without penalty. It's a bill by Representative Toole. So this bill allows teachers and school administrators in service after 35 years of creditable service to retire and collect retirement benefits without penalty. It also requires that a reemployed retired teacher or retired school administrator pay the same employee contribution rate to the retirement system as is required for the position if the position were filled by an employee who is not retired. So the sponsor indicated in his attorney that 35 years is a long time in the field and that this incentive would help with burnout. He also said requiring retirees who leave and then come back into the classroom pay into main purse helps avoid double dipping perception and helps keep main purse solvent. Representative Stearns, who is a co-sponsor, also testified that teachers begin at age 22 and after 35 years, they're 57. And it's very rare for educators to stay in the field for so long. and that this could incentivize graduates to pursue the education field. Steve Bailey of the Maine School Management Association also testified in favor of the bill. He said that it affects so-called cliff employees working in schools who did not have 10 years of creditable service when retirement law was changed back in 1993. And he also said that it gives educators whose passion and enthusiasm has waned an opportunity to leave the field. John Kozinski of the Maine Education Association said that a lack of a portable plan hinders late entrance to the profession. George Crawford of Machias also submitted testimony. He said that many educators who are burned out stay in the profession until reaching the normal retirement age to avoid the penalties. Nobody spoke in opposition to LD 111. Under neither for nor against, Kathy Morin of Maine PERS, she submitted testimony and testified, and that is attached to this bill analysis. She said that teacher that reaches 25 years of service, but is not at normal retirement age, which is 60, 62, or 65, sees retirement benefit reduced 6% for each year below the normal retirement age. She pointed out that the Maine Constitution does not allow the creation of new or additional benefits unless immediately and fully funded. And new benefits are created under this bill because a teacher would be receiving benefits for more years than currently accounted for and funded, which creates a new unfunded actuarial liability known as UAL. And it's approximately $83 million increase to the UAL if enacted. And there is an approximate $1.6 million per year cost for ongoing increased normal costs. And William Lobenstein III of the Maine Association of Retirees also submitted written testimony. So potential issues or technical problems that the committee wants to consider. So as noted by Maine PERS, the Maine Constitution requires new benefits to be fully and immediately funded. And this has been estimated to be $83 million. You can see Article 9, Section 18A of the Maine Constitution below. And this section right here says unfunded liabilities may not be created except those resulting from experience losses. So there was somebody on the committee had requested some additional information that Maine PERS had sent to me. So they provided a chart with their state-sponsored plans, and they provided 2 links to the Federal Social Security Administration that discuss the windfall elimination provision and the government pension offset. If you have the document open on your computer, you can click there. And I believe also that these are posted pretty prominently on their website at mainpers.org. So we have received a preliminary fiscal impact statement, which I have also attached. As you can see, it's $83 million for fiscal year 2021 and 2022. So under current law, a teacher who's a member of Maine PERS, the state employee and teacher retirement plan, they become eligible to retire by either reaching 25 years of service or by reaching the applicable normal retirement age, which again is 60, 62, or 65, depending on service requirements at specific dates set in law. So a member with 25 years of service who retires prior to reaching normal retirement age will have their retirement benefit reduced by a certain percentage, which is either 2.25% or 6% for each year that their age is below normal retirement age. So this bill creates an unfunded actuarial liability, UAL, estimated to be $83 million, which would need to be funded immediately. So the bill would also increase the normal cost component for teacher members by 0.15% of payroll, estimated to be approximately $1.6 million per year. Under current law, normal costs are paid by local school administrative units. Contributions from the requirement in this legislation that a reemployed retired teacher or retired school administrator pay the same employee contribution rate to Maine PERS as is required for the position if the position were filled by an employee who is not retired will accrue to the trust fund. And the only other thing that I have on this bill is I did include Maine PERS testimony as an attachment because last I knew, I don't think that it was posted to the web. So I just wanted to make sure that you had it in advance of today's work session. I'm happy to try to answer any questions.
I believe you're muted, Senator Rafferty.
That was by design, I'm sure. Representative Sylvester, you had your hand up first, followed by Representative Prescott, please.
I actually just have a piece of housekeeping, which is we closed the prior work session without asking the Republican caucus what their minority report was. And so just to make sure that we didn't all leave before asking that, it wouldn't be the proper time to do so now. But when we get to the end of this work session, to make sure that the minority party is able to record their.
And I apologize for that. That's my fault.
Thank you for pointing that out. Representative Prescott, please, sir.
Thank you. Can you put in blue collar terms this cost component, the increase the cost component?
Well, lucky for you, we do have Kathy Morin from Mainford, who is I'm sure more than happy to discuss the $83 million unfunded actuarial liability. So with the leave of the chair, Kathy Morin can certainly answer those questions.
All right, I'll lower my hand. All right, I'll do that. Now how do I get rid of my thumbs up?
Should I go ahead?
Yes, I'm sorry. Go ahead.
That's okay. Thank you. Good afternoon. Thank you for the question. So the UAL, the $83 million is basically represents the past liability costs, so to speak. So for the service that's already been rendered by teachers and the liabilities that have already been calculated for the teachers that are in place, the $83 million represents what it would cost for those past liabilities that have already been accrued to translate in essence over to this new plan of being able to retire with 35 years without any kind of a reduction in penalty. So that brings their current 25-year plan with the retirement age of 60, 62, 65 into the 35 with no age plan requirements, and funds the cost of bringing them into that plan. Does that answer your question? You're muted, I'm sorry.
Prescott, you're muted, sir.
Hey, best question ever. I understand the 83 million. So 1.6 million, is that additional cost to make the program work?
Right. So the UAL represents the past service liability, so the benefits that had already been accrued. The 1.6 million represents the ongoing costs for the teachers to earn their ongoing service credit in that new plan.
All right. Thank you.
You're welcome.
That's it.
I think we had Representative Bradstreet, Drinkwater, and then Senator Guerin, please.
Hey, thank you. I actually have a couple of quick questions. And I'm just asking if the $1.6 million we just referred to would constitute an unfunded mandate, since it would be up to the local school board to pay. And secondly, if a school teacher should serve 35 years and retire, we'll say at age 57, they can either defer the retirement benefits or they can start taking them immediately, in which case they would be reduced amount because they're taking them at an earlier than normal retirement age. Is that true, or can they excuse me, and if they do defer until we'll say age 62, then there would be no penalty, no offset or no penalty?
That is right. That is correct. If a person retires and starts drawing effective from that date forward, if they were, of course, you don't typically see a teacher defer retirement and lose those years of benefit. So if they start drawing at their retirement age, they're not going to collect the retroactive benefits. Again, that's not something we typically see, but they certainly could do that. I'm not sure why a person would give up those additional years of benefits. Not sure I understand your question.
Well, would the benefits then be reduced amount if they do defer, if they don't defer? In other words, are they going to get the same at age 62 as they would at 57, or will they get more at age 62 if they started at 62?
Right, if they started at 62, they would not be reduced, and so their lifetime benefit they would get a little bit more per month because they're going to receive over a shorter period of time based on life expectancies.
Right, same as Social Security, in other words. Right.
Right.
Thank you.
You're welcome. And on your first question, I would defer to Steve, I think, to determine whether there's a unfunded mandate.
My comment on that is the fiscal office is the one that typically, but not always, flags those. And they did give us the preliminary fiscal note and it didn't have an unfunded mandate attached to it. But depending on the direction that this goes or any amendments, they'll definitely review the bill again. And that could be subject to change potentially. But typically the fiscal office is the one that makes that determination, and the committee can sort of agree with that or kind of refute that. But there isn't one at this time.
Representative Drinkwater, followed by Representative Cuddy.
Thank you, Mr. Chair. Question for Maine Piers. I know in the past, it used to be that a teacher could retire after, let's say, 35 years of service, and then they could go back to work and receive their retirement plus a salary. I haven't been in touch with that for a while. Could you just touch upon what is going on with that now?
Sure. So a teacher who retires, there's a difference between the rules if they retire below or over normal or at normal retirement age. For those who are younger than normal retirement age, they have restrictions as to how long they can go back to work, and that's because of federal, because of federal law requirements. Anybody who retires who's at least normal retirement age can go back, and there's not a limitation on how long they can go back. Either last year or the year before, the legislature amended those rules. There used to be some limitations on how long a person could return, how much they could earn, that sort of thing, but those limitations are no longer in place. So a teacher who retires and goes back to work after normal retirement age can in fact do so, and they would receive their retirement benefit from us as well as their salary.
Thank you. If I may just have a quick follow-up, Mr. Chair.
Yes, go ahead.
Thank you. The $83 million, what we're saying is if this passes, appropriations is going to have to find $83 million?
That's correct.
Thank you.
Representative Cuddy, please, followed by Representative Bradstreet and Sylvester.
Thank you very much, Senator. This is, in my mind, the right policy. Teachers ought to be able to do this. I know that if this passes this committee and it passes the House and Senate twice, that it goes to the appropriations table. And appropriations is going to look at this and they're going to say, $83 million does not exist for us to fund this bill, and it's likely going to die right there. I understand that. But as a policy committee, I feel like it's my job to vote on what is the right thing to do. And for me, this is the right thing to do for teachers. I really thank Representative Stearns for bringing this forward. This is the way we ought to be treating our teachers, amongst many other changes we ought to make. But I know that if I vote to move this through and it's successful and it clears both the House and Senate twice, that there isn't $83 million. That doesn't exist right now. And that's fine. If that's the end result of the bill and it dies there on the appropriations table, then that's the way it goes this year. But I'm going to be supporting this as an idea because we're a policy committee, and it's our job to set what we think the policy is that the state of Maine ought to be following. I understand the financial realities right now, and I know that appropriations and financial affairs is going to look at that, and they're going to see that there isn't money for this bill. But I believe it's the right thing to do for our teachers, so I will be voting to support it.
There were hands up earlier. I'm not seeing any now. Representative Prescott, sir. followed
Yeah,
by
well,
Senator Berman.
Oh, thank you. So if we pass this, what's to stop from parlaying into every other job sector supported by the state? Shouldn't all state employees be able to participate in this and retire early if they made it 35 years?
If you're asking me, sir, I don't have the answer to that specifically, but there might be someone here that does.
That was more just a statement, you know.
Well, but I think it's an honest question, and I do know there are people that retire, you know, without an age penalty. Senator Murmont, please.
Thank you, Mr. Chair. I move this ought to pass.
Thank you.
Second.
Seconded by Representative Sylvester. Any other discussion? Alyssa, I'm going to ask that you take a roll call vote, please.
Looks like Representative Bradstreet stuck in at the last second there.
I'm sorry, Representative, I saw your hand up, then it went down. I missed it.
Yeah, it goes.
Representative Bradstreet.
It's
Go
like
ahead.
a yo-yo. Well, the $83 million does bother me. It's one of the big reasons I'm going to vote against this. And I do think that we have to take a look at the total cost of any bill that comes before our committee, especially one that's this big. I know teachers would like it. I think Representative Prescott asked a very valid question. Where will it stop if we start this precedent? Then we're going to be looking, you can be sure, next session for more requests for like benefits. People taking retirement benefits at a certain age is their choice. They've opted to do that at a particular time, just like I did when I opted to take Social Security early and got a reduced amount. It's a particular choice an individual has to make for himself. I think this would be unfortunate to pass this. I think it really should be defeated. I know when it goes to appropriations, that's just a very few number of people who, because of the cost of things and effect, do set our policy to a large extent. So I will be voting against it. And thank you. Appreciate the time.
Thank you, sir. Senator Murmont, hand was up, and then Representative Sylvester.
Sorry, that was leftover hand up. I'll get it down.
No problem, sir. Representative Sylvester.
I will be voting to support this bill, and I think that you know, along the lines of what Representative Cuddy had said earlier, I think that it's the job of this committee to think about what the legislature ought to do, and we are asked in the Labor and Housing Committee to think about the issues and matters of jurisdiction that are in front of the Labor and Housing Committee, and I guess I think of the right thing to do. Not as some jar that sits up on the top shelf that we pull down every once in a while and let out a little if we have the money to do it, or we have the will to do it, or, you know, we say, well, we can give a little to children this time and a little to, you know, but the elderly don't get any because we wouldn't want there to be too much justice. You know, I think there's a whole committee that thinks about whether or not the state can afford to do the right thing at a moment in time and a moment in history. And I think that if the money is not here this year, that they will hold it on the table, and, you know, it will carry over to the next year when maybe we are doing much better, as happens to many bills. And so I will be voting to support this because I believe that teachers, much like when we talk about firefighters and when we talk about police officers and other first responders, that it's a very it's a distinct profession that I think people should be rewarded for having spent their life teaching our children, and so I'm going to let appropriations worry about where the money will come, and I will answer their questions if asked about what I think about that, which is our role on this committee. But I will not do their job for them. Thank you.
Seeing no other hands, I'm gonna move the question, please. Alyssa, would you do a roll call vote? And again, keep in mind that a yes vote means yes, ought to pass. No means obviously no, it should not.
Senator Rafferty.
Yes.
Rafferty, yes. Senator Guerin.
No.
Guerin, no. Senator Miramont.
Yes.
Miramont, yes. Representative Sylvester.
Yes.
Sylvester, yes. Representative Bradstreet.
No.
Bradstreet, no. Representative Cuddy.
Yes.
Cuddy, yes. Representative Drinkwater.
No.
Drinkwater, no. Representative Gear.
Yes.
Gear, yes. Representative Morris.
No.
Morris, no. Representative Pebworth.
Yes.
Pebworth, yes. Representative Prescott.
No.
Prescott, no. Representative Rader.
Yes.
Rader, yes. Representative Warren.
Yes.
Warren, yes. That is 8 yeses and 5 noes with no absent.
Okay, what's the minority report on this one, if there is one?
Ought not to pass?
Ought not to pass.
And Steve, before we leave, do you want to do the same for LD 61?
I do. I apologize for not catching that before. Happy to take the minority report for LD 61, Representative Stern's bill.
Ought not to pass.
And again, I apologize for that. Thank you for your patience with me adjusting to my new role. So.
Well, we're all adjusting, Steve. You're doing a great job, so hang in there. Folks, thank you for your time and all your work and attention to detail today. I appreciate it very much. Thanks for viewers for out there listening and hanging with us. And for all those folks that took the time to testify, we appreciate you doing so. Your expertise is a great help to us, and we hope to hear from many of you again. That said, I'm going to close today's work session, and we'll see you folks on Wednesday, I believe. All right. Have a great evening, and thanks
night.
again for all your work. Take care.
Thanks, everyone.
Thank you.
Thanks.
Thank
Good
you.
night.
So.
Have a great night.